Hi. As Jennifer mentioned, I am Andrea Marsh with the Texas Fair Defense Project. And we work to improve public defense systems in Texas, so we do a lot of work with public defender programs such as the West Texas office. But today I'm mostly going to talk about our work to make sure that defendants who qualify for a court-appointed lawyer can get access to that lawyer if they want them. My office has done a lot of research on access to counsel in the courts. We also run an intake program where we provide direct assistance to indigent defendants who have requested counsel and who have been denied, and help them sort of overcome roadblocks that they may encounter when they are trying to get their request for counsel processed, whether that is helping them get together the right paperwork they need, or if a judge is denied counsel on a basis that we don't think is supported by statute, we will try to reach out to that judge and work with them. And we've also been involved in some litigation about access to justice, including the Roth-Gary versus Gillespie County case, which recently talked about when the right to counsel attaches in Texas, which is, according to the Supreme Court, at magistration or the 1517 hearing. What I am mostly going to talk about today, though, is a research project that we have been working on since 2006, looking at access to counsel policies in Texas misdemeanor courts. And to do that study, we had two primary modes of analysis. We first did a statistical analysis of court appointment rates in misdemeanor courts in Texas. And we calculate those appointment rates just as the task force does by looking at the number of appointments that Texas counties report to the Office of Court Administration and dividing that by the number of cases filed in your jurisdiction. And that gives us a rough sense of what your appointment rates are and gives us sort of a snapshot of how many defendants in your courts are getting access to court-appointed counsel. Now, these are some task force charts. I got these from Jim a year ago that show sort of felony appointment trends in Texas. And these sort of visualizes what the task force has done. I'm going to talk to you about our data. I have had some problems getting my tables into a PowerPoint, so I'm just going to talk about my data verbally. What the task force has done when they look at appointment rates is they are interested in average appointment rates sort of at a statewide level. So they'll take the total number of cases in the state and the total number of appointments in the state and come up with a statewide average. And they have at times broken that down into different county sizes, you'll see here. My organization was most interested in looking at county by county differences in appointment rates. And so we looked at the median and mean appointment rates for Texas counties. We calculated an appointment rate for 254 counties, both for felony courts and county courts, figured out what the average appointment rate was looking at those county appointment rates instead of a statewide average, and we also looked at the median rate. When you look at those rates, you'll see that Texas has a relatively high appointment rate in the felony courts. For fiscal year 2008, the mean appointment rate was almost 90% in the felony courts in Texas. So that is a lot. That's the overwhelming majority of defendants getting access to counsel under the sort of indigent defense program. And what you also see in the felony courts is that the median appointment rate is quite close to the mean. So the average appointment rate is pretty representative of where sort of like the middle, where most counties are. There's not a ton of sort of outlier counties either above that or below that, even though you will see that smaller counties do tend to trend a little bit lower in their appointment rates. When you switch to misdemeanor appointment rates, though, you see that far fewer misdemeanor defendants are getting access to appointed counsel in the county court system. So the task force, when they look at the average statewide rate, that rate is about 35%. However, if you look at what the average county appointment rate is, that is only 18% in fiscal year 2008. And in fact, the median rate is much lower. It's below 10%. So, more counties are below 10% than are above a 10% appointment rate in the misdemeanor courts. And the reason that there is that sort of discrepancy between what the statewide average is and what the median and mean is, if you look at the county appointment rate, is that the larger counties in Texas have much higher appointment rates. And since they have higher caseload, that sort of pulls up in a somewhat misleading way what the statewide average is, when you really have half of the counties below 10% and another 25% of Texas counties in that 10 to 20% bracket. So 75% of counties are below 20% appointment rates. So we knew that's what the statistics said, and those statistics have been pretty stable ever since the Fair Defense Act was passed, and we've seen county statistics. There was a slight upward trend in felony appointment rates in the median rate, and we did see one bump in the average misdemeanor appointment rate at the county level in fiscal year 2008. We don't have the 2009 data yet, so we're not sure if that's a trend that possibly could have been caused by HB 1178, which is legislation that passed in 2007 that dealt with how counties interact with pro se defendants, or whether that's just a data glitch. And we really won't have a better idea of that until you guys send in your fiscal year 09 numbers, which should be happening soon. But we've known these numbers have been like this for a long time, and we've been talking about them for a long time. And the question that I normally get is, well, you know, what does that mean? What does that tell us? Maybe, you know, misdemeanor defendants want counsel. Maybe they're just waiving their right to counsel. And, you know, the data themselves doesn't really show us, you know, I've been questioned whether that really shows whether there's a problem. So in order to sort of dig beneath the data, we went out and did a statewide study looking sort of at what counties were doing across the state, where we selected one county from each of the state's 9 administrative judicial regions, and we have made 3 visits to each of these counties to document their court appointment practices. We went to each of these counties 2 times in 2006 and got baseline data where we observed misdemeanor court. We interviewed judges, magistrates, defense attorneys, prosecutors about how they handled their court docket. And that gave us some of the baseline data that actually supported passage of HB 1178 in 2007. Then we went back to each of these counties in the fall of 2008 and early 2009 and looked to see what, if anything, had changed since HB 1178 had passed, if the counties had felt that they needed to change any of their procedures in response to that statute, and you know, whether some of the problems that we had seen before HB 1178 had passed had persisted into 2008 and 2009. When we went and performed these site visits, we were interested in 4 primary questions. The first is, are defendants provided accurate information about their right to a court-appointed attorney at their initial post-arrest appearance before the magistrate? And are they informed of the procedures for requesting counsel and given an opportunity to apply for counsel at that time? So we would go to magistration and see if the defendants were given information about their right to counsel, but also see if they were given the forms. And sometimes counties, the magistrate might ask them if they want a right to a lawyer, but the forms weren't given to them, or the forms were only available in jail, and sometimes the jailers weren't equipped to help process them. So that was one thing that we would go look at. We also looked at our requests for court-appointed counsel submitted at the magistrate hearing, timely processed and ruled upon, including requests submitted by defendants who are subsequently released on bond. We looked at, are defendants provided accurate information about their right to court-appointed counsel at their first appearance in county court? And are they informed of the procedures for requesting counsel and given an opportunity to apply for counsel at that time? So under HB 1178, the Court of Jurisdiction also has an explicit obligation to advise defendants of their right to counsel. They can't rely on the magistrate warnings that are given at the 1517 hearing. So we look to see, are the courts doing that as well when defendants come in for their first appearance? And finally, are unrepresented defendants directed or encouraged to talk to a prosecutor? And if so, are defendants informed of the right to counsel and given an opportunity to apply for counsel before that occurs? So the site visit findings, and these are findings that were sort of persistent problems. So we had a lot of things, we saw some things in 2006 that had been addressed by the time we went in 2008. And so the problems that we have up here are problems that have persisted into our second round of site visits. We observed many counties where judicial admonishments regarding the right to counsel were incomplete or misleading. I think the 2 things that we saw most often are judges telling defendants that they have a right to a court-appointed counsel at trial, and not making clear that they also have a right to counsel if they are interested in entering a guilty plea, or to help them decide whether they are entering a guilty plea or going to go to trial in their case. So you'd have a lot of plea hearings where defendants would show up and be told that if you're going to go to trial, you have a right to counsel, but not told that they had a right to counsel that day when they were evaluating a plea offer. I think the other issue that we see in terms of the accuracy of admonishments is there are lots of courts that we go to where defendants are told, you have a right to court-appointed counsel, but you will have to pay the county back if you get one. Now, there are circumstances where a county can require a defendant to pay the cost of court-appointed counsel back, but that can only be done if the judge makes certain findings at the time that the repayment order is entered, which is usually at the time of conviction. So we talked to a lot of defendants who felt that, you know, I'm on Social Security, I'm never going to have more money, I don't have enough money to pay for a lawyer now, I'm not going to have enough money to pay the county back for a lawyer later, so if I have to pay the county back, I'm not going to ask for a lawyer, I'm just going to try to work it out by myself. Now these are defendants who probably could not have a valid repayment order entered against them because they would still be indigent at the time the court was considering whether a repayment order was appropriate. And so telling all defendants that sort of in a blanket way that no matter what they're going to have to pay the county back led defendants to kind of not have a complete understanding of what their rights are in terms of accessing counsel and under what circumstances they could be required to repay the county for counsel. Another issue we saw is that although most counties have objective criteria for determining who is indigent and qualified for court-appointed counsel, that those criteria are not applied uniformly. Most often we would see that with defendants who were on bond and or employed. So the county might have, for example, a standard that says you're qualified for a court-appointed attorney if your income is at or below 125% of the federal poverty guidelines. The defendant would bring in information demonstrating that their income was in fact below the level and they objectively met the standard, but they would still be denied counsel, and sometimes the court wouldn't even look at their financial information because the defendant was on bond or had a job. And just the court would sometimes apply a shorthand evaluation instead of looking at whether the defendant could meet the county's published indigent standard. We also, in 3 of the 9 counties we went to, saw that defendants who were arrested and subsequently bonded out, if they told the magistrate they were going to bond out, they weren't even allowed to request a lawyer at magistration. The magistrate would say something along the lines of, you have a right to a court-appointed lawyer, but if you're going to bond out, don't ask for one now. Or if they asked for one, are you going to bond out? Well, just ask later. This violates Article 1517, which says that all defendants have to be given an opportunity to apply for counsel at magistration. And it also leads to problem when defendants show up later. If they initiated or indicated a desire to request counsel at magistration, and then when they come back to court later, they're given sort of different information. It's very confusing to them about what their right to counsel is, and it also makes it impossible for them to get a lawyer before their first court appearance and sort of come to that first court appearance, which is a critical stage in their case, represented by counsel. We saw other counties where the defendants were allowed to ask for a lawyer at magistration if they were going to bond out, but those requests weren't ruled upon. There is one county we went to where they literally had like 3 years of requests for counsel of defendants who had bonded out sitting on top of a file cabinet in the Indigent Defense Coordinator's office, and they were just never matched to a file. They just kind of sat there. If the defendant bonded out, she wouldn't file them, she wouldn't send them to the judge, she just left them on top of her file cabinet. Since HB 1178 has passed, this is a particularly serious problem because judges are not allowed to sort of direct defendants to talk to a prosecutor, and prosecutors cannot speak to defendants who have a pending request for counsel that has not been denied. So, these defendants have pending requests for counsel. The court of jurisdiction is not aware of it because those are never matched to their court file. The prosecutors are not aware of that when the defendant comes to court because those requests are not attached to their court file. If the prosecutor talks to that defendant before the request for counsel is denied, which it usually is never denied because the court doesn't even know it's there, the prosecutor is violating HB 1178. Any waiver of the right to counsel is presumptively invalid. The court cannot cannot meet its obligations under HB 1178 to how it's supposed to interact with defendants who have pending requests for counsel. And so judges and prosecutors at arraignment docket don't have the information they need to comply with the law and get a valid waiver of the right to counsel. And we also saw counties where defendants approached defendants, or prosecutors approached defendants before the judge admonished defendants of the right to counsel, and one county where even if a defendant had requested counsel, the prosecutor would approach them even though that request had not been ruled upon by the court in any way and was outstanding. So, those are some of the problems we saw. Most of them are actually pretty easily redressed, and when they are redressed, the counties have a much better chance of getting valid waivers of the right to counsel from defendants who truly do wish to waive their right to counsel and represent themselves in misdemeanor court. And also defendants who do want to access counsel are going to have a much easier time doing that and will have sort of better information, be able to make more informed choices. And we also think that when these best practices are implemented, that the courts are going to run more smoothly. We saw a lot of courts where defendants would show up without a lawyer, they would have to get a reset, they didn't know what information they were supposed to bring for the right to counsel. A lot of these best practices can also just help you avoid resets and avoid the need to ask defendants to come back over and over, again, with different information and with different documentation that you need to process their request. The first best practice that we identified in the counties that we went to are appointment of defense counsel at a defendant's first appearance before the magistrate or shortly thereafter. And this ensures that all defendants who have asked for a lawyer at magistration will show up for that first court appearance with a lawyer, and they are more likely to be ready to dispose of their case at that first court appearance. And it also reduces the need for counties to deal with trying to track down lost paperwork from defendants who didn't get a ruling on their initial request and who might show up for court later with a pending request. The next best practice is related to that, and that is an establishment of a system for matching requests for court-appointed counsel to the case file, including requests for counsel submitted by the magistrate. Again, we saw lots of counties where courts and prosecutors did not have access to the magistration information that they needed to comply with HB 1178. They didn't know when somebody showed up without a lawyer at first appearance who had and who had not requested counsel for magistration. If the county does not have a mechanism for matching those requests for the file, you can't really solve that problem. But several counties had come up with ways, they just sent the magistration form. It was matched to the case file. When the case was filed in the court of jurisdiction, courts knew what to do. The prosecutors knew who they were not allowed to talk to under any circumstances until a ruling had been done. And it just made it easier for all of the court actors to comply with their obligations under statute and get, if the defendant eventually did waive counsel, to make sure that waiver was valid. Several of the counties we went to also had indigent defense coordinators who were particularly knowledgeable about the right for counsel, had more time to talk to defendants to make sure they understood the right to counsel and that they understood the paperwork and understood what documentation they needed to provide. That saved the court's time, and they made everything seem to run more smoothly. We also saw many counties, particularly after HB 1178, that had developed forms to inform defendants of the right to counsel, explain the procedures for requesting counsel, explain what paperwork they would like to see demonstrating indigence, and explaining their reimbursement policies. Counties were able to get these to defendants as soon as they walked into court at the first appearance, and that seemed to help a lot of counties sort of address the requirements of HB 1178, that defendants get this information again at their first appearance docket when they show up in the court of jurisdiction, efficiently, make sure that information was uniform every time, and make sure it didn't vary depend on, what court officer was there on a particular day or what county court they were in. We also saw offices where the prosecutor office itself had a policy forbidding communication with defendants after the defendant had requested counsel or before the defendant had waived counsel. We had the sense talking to prosecutors who had the initial role of talking to unrepresented defendants, that the prosecutors themselves were not comfortable with that, but that they wanted to comply with the judges' wishes about how the judges wanted to run their courts, and some judges really thought that made their courts more efficient if the prosecutors could get out there first and take care of some of the waivers and the paperwork and talking. But that puts prosecutors in a really difficult position in terms of their ethical obligations not to encourage waivers of the right to counsel. And some prosecutors had policies not to do this at all and would work with their judges to come up with other policies that were more consistent with their ethical obligations. And the prosecutor's offices who kind of took that on themselves were more comfortable with their role, and we thought that was the best practice that we saw. And finally, the last best practice was implementation and really using the uniform criteria you have established for determining whether a defendant is indigent. Look at their paperwork, look at their income, and apply it to whatever your standard is. Whether that person is on bond or unemployed or employed, instead of using sort of shorthand presumptions, just take their paperwork and rule on what their numbers are. And that led to much clearer rulings. Defendants were not reset over and over again to hire a lawyer, even though they were bringing in paperwork showing that they met the objective financial criteria. And it sort of made the process go much more smoothly and quickly, and certainly was less frustrating for the defendants we spoke to. That is sort of the bulk of our study, and now I'm going to turn it over to Shannon, who's going to give a prosecutor's take on misdemeanor courts.